does the idea of intellectual property and its formal protection still have a place in our global connected world? Intellectual property, which I'll refer to ongoing as IP, refers to the output of creative intellectual activity, probably with some commercial worth. Similar to physical property, it can be bought and sold, it can be leased and licensed, you can make money from it. But dissimilar to physical property, intellectual property tends to be quite easy to copy, and indeed the act of trying to protect it can expose your idea to greater risk of being copied. But if you do have a novel idea, there are a range of formal IP protection mechanisms which you can call on to try and make money from your idea and to protect it. You have copyright, which is automatically conferred when you make a physical representation of your idea. So if you take the Harry Potter franchise, for example, the text of the book, the script of the film, the recording of the film, the images on the film posters, all of these outputs automatically have copyright applied to them. You also have trademark, which is any sign or symbol that allows your customers to distinguish you from your competitors. This can be very useful, it can help us with our buying decisions, but for organizations it can also be problematic as they expand their operations. So for example, Apple, the technical firm, and the Beatles recording label, Apple, operated in harmony for many years until Apple started to get into music publishing, at which point a trademark battle ensued. You then have patents, which protect the form and functionality of any new invention or innovation and the process by which it is made. Now, this is a lengthy and costly process, but it is the most defensible. And depending on which country in which you take out a patent, you can get up to 20 years legal protection. And a famous example of this was James Dyson, who used patents very effectively to ward off imitators as he captured the full economic value from his innovative cyclone vacuum cleaner design. Final formal mechanism that exists is something called design rights, which gives you a monopoly right for the look of a product, protecting both the shape and the pattern or the decoration. A famous example of this is the Coke bottle. It's quite distinct. We recognize that when we see its shape or its outline. The criteria for this is quite subjective. It should not remind an informed person of an existing design. So no asking your mum if this is something original, unless, of course, she's informed. These formal mechanisms are very overt. They require you to share details about your intellectual property to protect it. There's another very popular method, which is known as trade secret, which requires you minimizing the number of people who have knowledge of your IP. So an example of this secret formula of Coca-Cola, or perhaps a more Scottish example would be Iron Brew, has been protected for over 100 years by just limiting the number of people who are aware of the secret formulation.